With the consent of other side, my lord, I beg to mention item number 22, my lord. My lord, this matter may not be taken today, my lord. After vacation, it may be taken.
Item 22. You are the other side?
Yes.
Let it be come after vacation, ma'am.
So you are for the petitioner.
Petitioner, my
It's a transfer case
transfer petition.
with the consent of the other side. The learned counsel for the petitioner, Mr. Manna, require an adjournment. Prayer or listed accordingly after vacation and then a date. Okay, it will come after vacation.
That's high level.
Lordship, an additional affidavit has been filed on 19/9. Kindly that may be called
In which act?
item number 50.
Item number
15, 15.
15. You have filed the this when it was filed?
19/9.
19th.
Yes.
I see. Right. Okay, we'll try to follow.
I beg to mention item 14,
1/4.
1 for Lordship. English Council is out of stand. Let the matter be fixed on Friday
No.
or after,
Friday.
after vacation.
If it is
Interim
today,
order-
otherwise not Friday, maybe after vacation.
Yeah.
But do you
Interim
have
order
any
is there,
information in regards to whether that is this charge sheeted case?
No, Lordship,
Not charge.
not such. Interim
Is there any
Lordship.
idea?
Lordship, actually, my learned friend Kuldeep Boystoy is here, Lordship, on the way. So,
No, as you are on interim there,
Interim Lordship.
but we are not in a position to say whether the CD has come or not.
item number 14.
1/4.
CD, Lordship, will hear.
CD received? Yeah.
Lordship.
No other, we have to return back. That's why I'm asking.
Yeah. CD, Lordship, CD is here. Lordship.
CD received.
CD received.
On Friday, Lordship, let the CD return
Pardon?
on Friday.
Friday, we're not going to list. That's what I'm saying. It will be after vacation only, otherwise. The request made by counsel for the petition. Matter be listed immediately after vacation. CD received. CD be returned, calling for updated. Interim be continued building state of listing. List accordingly at the date because after vacation.
CD to be returned, Lord.
CD may be returned because after vacation.
Lordship.
15, 16.
Lordship.
May I please, your Lordship? Lordship, I may be mentioned,
Have a seat for some time, see.
all for the records of an IA in connection with the item number 4 of tomorrow's list, Lordship.
Tomorrow's list, we are not here. I did not hear.
Not for today, tomorrow.
Oh.
Not for today.
Vote number 8. Make
I
a
already
mention because
mentioned-
vote number 8.
Lordship, I already mentioned there, but the Lordship asked me to mention here.
Mention, we cannot hear. Dear the senior bench, that has to be there, or otherwise, if you have some problem, just approach the registry, it will be listed.
Lordship, the main case is listed tomorrow.
We are not
Vote
in a
number
position
4,
to say
Lordship.
anything. You just approach the registry. If I is already there, it may be listed together also. Let us see. Because we are not the senior bench, so you have any mention, you have to make it before the senior bench on vote number 8. If there is other instructions, then if you can approach the registry with that prayer. It
Oh,
may come.
Lordship, actually, I already mentioned there.
No, I don't know. You have to approach, otherwise registry. Approach registry.
Lordship.
May I please look? Item number 31, my lord. In this case, my lord, the notice is yet to be served. The other side not shown the entrance.
31.
31.
Notice yet to be served, or you have not taken any step.
We have taken step, madam.
But it is connected with item number
Yes, this is
32.
another case which has been filed by another council, set of council. So for my case, it's concerned,
There two respondents have already appeared, or what?
yes, in their case they have appeared because my parties are different.
What is the difference? It are 32 to no order.
31.
You know, to order.
I will place on, my lord mentioned that other side is suppose required to suppose make their submission, that is another issue.
Order. Let the matter be retrieved be here. I have already noted down your
My-
issue.
my-
So let it be.
No problem. But only thing that there is a stay order in respect of the interim order.
Pardon?
There is a stay order operating in respect to the interim order.
Interim was there.
Yes.
Okay, we'll get. Have disposed the petition without commenting the merit of the case or without commenting the amendments made in the transfer petition. However, considering all these aspects, as the complaint, one complaint is also pending before the Registrar General, the case has been transferred to court from court number 1 to court number 2. It is allowed.
Number 2.
This I is allowed, but I is allowed in a sense, not exactly, but you have to file a fresh petition before the learned trial court, learned member MSCT, with a justified reasons as to why the earlier counsel could not be there. So that reasons you justify and it will be disposed of. Otherwise, we cannot directly allow this. It's not allowing because there are the orders which have been filed by the learned member MSCT is quite reasonable order. So we make just justification in the case itself. That may be considered.
Please, your lordship. My lord, this is second time bail application, my lord. Earlier, it was rejected by this honorable court. The reject order is at page 24, my lord.
24.
My lord. At that time, initial stage, my lord, 67 days was there, my lord. But now today I am behind the bar for 80 days, my lord. So on the ground of length of detention, my lord, and breastfeeding child is outside, my lord. 1-year-old baby, my lord. On this two ground, my lord, I may be allowed. It is the case of 90 days, my lord. And 80 days I am behind the bar, my lord. And in the meantime, my lord, on the date of filing the FIR, the victim has been recovered, my lord.
Regarding the recovery, do you have anything?
Pardon, my lord.
No, you have submitted that the victim has already been recovered.
Already been recovered.
So do you have submitted anything in that support?
My lord, it is in the forwarding report, my lord. It is there, my lord, that the victim is recovered, my lord.
In which page?
My lord, at page 18, my lord. And my lord, page number 21, my lord. Page 21, my lord. The victim and the informant jointly filed a petition before the lower court, my lord, that if the bail is granted, they have no any objection. So from this line, it is also clear that the victim is recovered. Page 21, para 7.
So victim recovered.
Right.
Yes, question.
My lord, here, my lord, earlier when rejected, my lord,
Yes.
my lord, in page 25, my lord, these contents are at that point of time also, my lord, regarding that, my lord, that is the breastfeeding child, my lord. At that time, my learned colleague submitted, my lord, that is in page 25, the bottom of the paragraph, my lord. That is the KK task learned additional public prosecutor, some submitted in this regard that there was an order from the court to hand over the breastfeeding child to the petitioner. And in compliance of the said order, the IO visited the house of the petitioner in search of the baby. But then only it has come to the knowledge of the IO that the baby is staying with his father, husband of the petitioner, who is missing from the place of residence, for which the order of the court do not be complied with. Now, my lord, in the next para, my lord, page 26, my lord, it is further submitted by Mr. Das that there are sufficient incriminating materials against the present petitioner, and from the statement of three victims recorded section 183 of BNSS 2023, it reveals that in the pretext of giving job and for other purposes, the girls were taken by the present petitioner and they were engaged in prostitution. More so, she admitted in her statement that she herself is engaged in the trafficking of girls who were subsequently used in prostitution. My lord, in the last, my lord, before, my lord, that is the, before, the last paragraph, my lord, before that, my lord was pleased, my lord, that hearing the submission made by learned counsel for both the sides, considering the materials available in the case diary and the statement of the victim record that under section 183 of BNSS 2023, this court is of the opinion that further custodial interrogation may be required to unearth some more facts. My lord, at that point of time, they admittedly 67 days. Otherwise, my lord, allegation is very serious, my lord. And after perusing the CD, my lord was pleased to reject the bail petition. And regarding that, my lord, that is the baby child, my lord. That, my lord, part was that time also, my lord, that was also recorded, my lord.
No,
So,
that was already there.
yes, my
We are only on the length of detention if you have anything to say, sir.
my lord.
Only
don't-
on the length of detention because
Yes.
I don't know, 80 days may have,
My
might
lord.
have gone
As
already.
per their statement, it is 80 days, my lord.
Ah.
Otherwise, it is from Nalbari, my lord. Well, we can take one date, my lord, if any upgradation or any something else is
We
there, my lord.
don't have any date now.
Yes, my lord, because my lord, it will be difficult.
Cannot fix it.
Yes,
Or otherwise at 2, we can take it at 2.
my lord, whether my lord search sheet is submitted or not.
Or what is the stage of?
What is the stage? That
investigation,
maybe we can take a telephonic instruction, my lord, at
At
that
two?
point of time, my lord. What
At
is the
2 PM?
stage, right? At 2, my lord, we take a instruction.
Obligement.
My application. Well, so it's a 483 application also for grant of regular bail also. Earlier also the petitioner approached the honorable court by filing anticipatory bail in, it is at page number 40 also, annexure 6.
It's a case of commercial quantity.
Yes, your lordship.
Earlier it was rejected, now it has already been charged or not? yet
No,
charged?
it's the proceeding is going on, your lordship.
Proceeding is.
The direction was that the petitioner may appear before the concerned prime court, and accordingly the petitioner appeared and he surrendered before the court and he was
Now
taken into
he is in
custody
custody since when?
since 19/4/2025.
19/4.
Yes. Your lord. And so far 2 seizure witness has been examined, your lord, out of 3, your lord.
See, at this stage too, which is not possible, yes, question anything to submit.
My lord, the scan copy make a call for my lord.
Has
After
to be
peak,
there.
after vacation, my lord.
Obviously after vacation.
After vacation, my
Now it's a case of commercial quantity, so we have to
commercial
peruse
quantity,
the
my
case.
And
We need to
your
go through the
lordship, your
same-
lordship, out of these 3 witnesses, 2 they have already deposed their evidence, and none of the witnesses deposed anything against the
No, these are all seizure, I think.
seizure witness, your lord.
And the full officials of seizure officials or otherwise.
No,
Other
just-
seizure,
No, independent seizure.
independent seizure.
Yes, sir.
That is the reason I just, we want to see direct. So yes, scan copy of it is here be called for. Registry will do the needful, it's accordingly immediately after vacation and it did. 15, 20, 17, 17.
Yes, sir.
Right, my lord, this is commercial quantity matter. Already charge sheet has been submitted.
So
So
why it is listed? Earlier it was rejected.
first time,
Here is it there. I got a rejection, no?
Planet trial court has rejected his bail application, madam.
That is okay. It can cover. Your petitioner's name is?
Lordship,
Your petitioner's name is? What is your name of your petitioner's
Mukta.
name?
my lord, Muqtajul Ali.
Muqtadul Ali.
Yes,
It was earlier rejected, I think.
I have.
Otherwise, should not come before this court. By this court, whether it was rejected earlier,
No, my lord.
but as per our record, it is there on the order, but there.
My lord, as per my instruction, my lord,
Going to tell. বলবো না কেন inquiry?
because I have
Made any inquiry?
I have made inquiry as per my instruction.
You have filed your affidavit here?
Yes, my lord.
What your affidavit says? You should make an inquiry.
Lordship, my lord. Let me also
For
check.
filing, you should make an inquiry because if it is not there, then how can we say? No, it is our official record, that's why I'm just saying. Otherwise, there is nothing.
So if it be, my lord, I may sometime I say to inquire, my lord.
No, it was there only. We have find the record.
Record is there.
The report is there. But your affidavit or your petition is silent in that regard. Or you're not aware of that.
I'm not aware of it. As per.
Better you should approach your, I mean, sorry, attest the earlier rejection order also. Earlier rule I did. It was like 1508. You file an additional affidavit and attest the earlier rejection order.
Right.
We'll just check it and we'll tell you.
Or otherwise, my lord, I may allow to withdraw and file. Because this.
I may be wrong, but there are two instances, two orders are there, two disposal things are there. So that's why from there only I'm saying that there might have some disposal order earlier. Rejection or I don't know what is the, maybe rejection.
I'll check it.
Standing in. Here the respondent sites are not there.
No, Lord.
You have not taken steps.
Steps already taken, Lordship. I first take steps.
Was an order on 22nd of December 2022. The matter was first came up.
Right.
And where the order of issuance of notice was there, but I don't know urban or.
I take first steps.
If say address is not found is there only.
Yes.
Otherwise, we have received the LCR.
Yeah.
So it was the case for special drive for mediation in fact, but other side it is not there, so it
Not-
takes it.
right.
Okay.
Yes.
Hard Mr. And Amin.
And Ahmed.
I'm running counsel for the appellant. This was fixed for regulatory mediation. But on perusal of the record, it is seen that the respondent, notice on the respondents are not yet served. And the earlier notice, which was, and the earlier notice also returned answered. In view of this, the appellant is hereby directed to take the steps on the present address of the respondents to register the and as usual process. After completion of the service, the matter may be referred for mediation. Please the matter immediately after the mediation.
May please, Rohit.
May it please lordship, I'm on behalf of Mr. M. Soikia. Please pass forward the matter.
For M. Soikia.
My lord,
Yes.
what happened, my lord, I will have to take instruction, my lord, as regards mediation, my lord. So let the matter be taken up, my lord,
Oh,
immediately after.
actually, you are for the appellant or?
Yes, I am for the appeal.
Then you are for
Respondent.
Respondent. Kindly lordship pass.
respondent. The respondent name is not reflected here, that's why I'm.
My lord.
Name of the council for the respondents are not reflected
Yes,
here.
my lord. But in the, my lord, column of the, my lord, petitioners, the name has been reflected. Both, my lord, petitioner appellant, Mintu Soikia. No?
Yes, both the councils.
Yes,
are
yes,
in-
that's the problem.
Okay,
Ma-
then we'll list it.
After, my lord,
Now, what is about the mediation
my
referendum?
lord, that, my lord, I will have to take instruction, my lord.
Do you have any instruction in that regard?
Lordship, actually, I am not properly
Aware about the case?
so kindly typing the matter.
No, no time being.
After,
He is asking time, and that part the case was fixed for mediation. So he will take instruction as well as ask your and this council also may take instructions from your client.
Lordship, according to my senior instruction, some inquiries required. That's why,
Some.
according to my senior instruction, senior says timing the matter. Some important point are there.
No, I can understand. You are not aware about the case record. It is okay, but case is fixed for mediation. But as Mr. Sharma is saying that it may not be possible at this stage to fix it in mediation because he has to take some instruction. Same instruction you also take whether your party is interested to fix it before the mediation. That's all. No, nothing adverse, no order. There cannot be any otherwise. I heard Mr. R. Sharma, the learned counsel for the appellant, and also heard your good name.
Vidas.
Pidas, MS Pidas, appearing on behalf of Mr. M. Saikia for the respondent. It is submitted by Mr. Sharma that he has to take instructions from his client as to whether the case may be referred to the mediation. In view of this, the respondent is also here, the counsel for the respondent is also hereby asked to take necessary instructions from their clients, the respondents, to send it before the mediation. List the matter accordingly immediately after vacation as an date will be by the registrar. And getting the instructions, the matter may be referred for mediation. It will be after vacation.
Amicus That's nice. POXO matter, but my lord, amicus is not available.
Amicus was appointed on the last.
Already appointed, my lord. Maybe some difficulty with.
Lordship, in this matter, I don't want to go with the matter, merit lordship. The important fact is that lordship provisions for
Next, further it is submitted by MS Chaudhary that earlier the prayer, the respond number 6, that is the name of the performance defendant, was already struck due to her its death, and at present, as per her information, the respond number 5 and 7 died or what? Died, Lord. Respond number 5 and 7. The performer respond number 5 and 7 already died during dependency of this. And accordingly, she prayed for striking out the name of respond number 5 and 6 from the constant document. Prayer aloud. The registry will do the needful in striking out the name of respond number 5 and 6, 5 and 7 from the constant document. Please scan this one. The DCR has not yet received. Issue reminder, registry will do the needful. Let the matter be listed accordingly immediately after vacation as on a date will be fixed.
And the
Right.
Mate, please. Your
19
Lordship.
is with, 1, 2, 3, eyes are also there.
Your Lordship, in this matter, I will have to take instruction because our name is not in the cost list.
Oh. So Talukdar,
Look,
you are appearing for all
Badly,
respondents.
see, the order sheets, since 2021, they have been taking time and several advocates entered appearance. Plus, you can see the order sheets. Number of advocates entered appearance,
Number of advocates?
entered appearance. Took time.
See. Actually, what had happened on the last occasion,
Yes, Lord.
there was no one has represented the applicant.
Yes.
Talukdar was there. So Mr. Paul, R.C. Paul was there.
Yes, yes.
So he said that he will make an information to the company. So now you have been engaged.
Your Lordship, Learned Counsel KK Bhatta informed me that means Mr. S. Datta is representing my senior.
Your senior is.
So I'm not sure whether that's the
Do you
fact.
have any information, Mr. Paul?
I also communicated.
Ah.
So manager is out of station. So he said that I'll appoint you, me.
So now just tell us what to do.
That is, I don't know, because she was after the Loka Adalat, he was in out of station. So today is my lord, I confirm it. Because
So
tomorrow,
So we have to reflect one name.
yes,
So
that is why, that is the purpose. Because I do not know
But-
they have filed the Okalatama or not.
Your Lordship, I think we did not file. My submission is based upon Mr. KK Bhatta's information to us.
But KK Bhatta is not going to appear.
No, Your Lordship.
Yes, ma'am.
We'll take instruction, Your Lordship, and after vacation, this matter may be closed.
So today I also informed my lord, I communicated over phone. If nobody is appear, so I'll execute the Okalatama in my name. Okay.
You have already filed your Wakalatama? No, not yet.
No, not because he was in out of state signing authority. Anyway, if they were appointed, my lord, we, do that after confirming. Get the instruction.
They are also not sure. They have been informed by
that is the
Mr.
thing,
Bhatta that you are
That
already
is the
appeared.
thing, my lord.
Lordship, since 2021, they have been taking time, Lordship.
My lord, it
Now
will be
what
confirmed in
to
our,
do? See,
And on the other
Yeah, I-
hand, claimants are suffering.
yeah, obviously,
on Thursday it will be confirmed by. Based on
we
the,
are not going to fix any date.
my lord,
That we will
after
not.
vacation, maybe fix. in the
Immediately after
meantime,
vacation.
Okalatama is fine.
Heard Mr. S. Datta and also heard Mr. R.C. Paul appearing for the appellant and submitted that the company has not yet appointed anyone as a from the anyone for the respondent till date. However, they have some instructions regarding the appointment and accordingly create some more time to take the proper instructions regarding the appointment of the advocates from the panel advocates for the said instance. Mr. M. Talukdar is present for the respondent and it is submitted that case is pending since 2021 due to absence of the MP's counsel for the respondent for the applicant. In view of this, Mr. S. Datta and Mr. R.C. Paul is hereby asked to take proper instructions from the company, insurance company of the respondent regarding the appointment. Let the matter be accordingly listed immediately after vacation and then a date to be fixed. So you just take instruction and he is rightly pointing out the claimants are
Okay,
suffering since 21.
Much obliged.
Because of date of Mr. Date of A. Ahmed. After his death, hopefully.
Nobody is there.
Nobody is there.
That is the, much obliged.
Much obliged.
Lordship.
Yes.
And the petitioner.
Before going, my friend start, your lordship received the office date of 6/9/25. The Resono 6 expired
Oh,
Number 6 expired.
and 7/8,
Respondent number 6 expired.
and some brother accepted on notice, 7 and 8.
Suppose even if we take in consideration regarding this, so you are appealing for whom now?
I'm asking 1 to 3.
1, 2, and 3. So obviously 6 expired. As per the office. So take in. How many? 8 respondents altogether?
Yes, today the all 8 respondents.
1 to 3 expired and notice was issued to respondent number 4 to 8. And these are the service report on 6/10/25.
Otherwise, you are representing 1, 2, and 3.
Yes.
And I'll take steps upon that deceased respondents for substitution of the
You have.
heirs of
filed.
deceased respondent. That's it. I'll take steps. That's it.
Heard Mr. Mr. G. Kakoti, the line council. Mr. H. Kaur,
SR Gogoi.
SR Gogoi. SR Gogoi. SR Gogoi, yes, SR Gogoi for the respondent number 1, 2, and 3. From the office note dated 6/9/2025. The notice on respondent number 4 and 5 are served personally. However, the notice on respondent number 7 and 8 was accepted through the brother of the respondents. In the same time, from the office note, it also reveals that respondent number 6 expired. In view of this, Mr. Kakoti, the learned counsel for the appellant, submitted that he will take proper instructions and will file and interlocutory application for the substitution of legal heirs of the respondent number 6. In view of this, let the matter be listed after vacation, enabling the appellant to take necessary steps for substitution. List accordingly.
Right.
Okay, service is complete. Let me be listed for at
Actually,
least.
the names of some councils are also there.
That's it.
In the cause list, the name of
Order.
one council, Mr. H.N. Bordhuya, who is appearing for 1 to 6.
They are for the respondent.
Yes, yes. And Mr. M.S.N.J. Begum is appearing for 1 to 6, but they are not present today. Otherwise, your service is complete.
Service is as per order dated 17/3/2025.
Acha. Service. 7, 9. Particular. So there is an office note on 2/8/2024,
Lord.
whereby it is stated that the learned counsel, Mr. M.H. Ali, appearing on behalf of the petitioner, submitted that the respondent number 8, 10, 17, and 18 are not the necessary parties in the instant petition, and as such, the respective name of the state respondent may be struck off.
Is that?
So have you made a prayer before the court also? Because office note says so, otherwise, I don't know.
Lord.
It is in the office note only, whether there is any order.
Oh.
No, whether there is any order regarding the striking of the name of so and so.
As per order dated 17/3/25.
17/3/25.
Para number 3, it is seen from the office note dated 6/9/2024 that service upon the respondent number 7, 9, 11, 12, 13, 14, 15, 16, and 19 is complete. And their performance, Lordship, 1 to 7 are in.
It was with regard to Bill 8, 10, 17, and 18, council for the MH can be submitted for the Lojima board. The Lojima board of submit to the upper to strike up.
One to seven are the main opposite parties. And all have received the notice.
Now, what is your stand here before the Lojima court? There's a, submission from your side that is 8, 10, 17, and 18 can be struck off. They are not the
Start.
necessary part.
Because they are the
Can we record this submission here now?
there is no such record. I am not. Order.
No, I'm not saying that. I'm saying that as per the Lojima order,
Nothing.
there's an order that you have submitted before the Lojima
No.
court that 8, 10, 17, and 18, they're not the necessary party. I'm asking you whether their names of those respondents can be struck off. That your submission will be recorded now. That's why I'm asking.
Maybe.
Recorded? Your good name?
What is it?
Who is Mr. M.H. Ali?
Ali, he was my junior.
So your good name, kindly?
No, he appears before the lodging.
Your good name?
Yes, sir.
S. Sahad. जी हाँ सर A. Sahad. Hard Mr. A. Sahad, the learned counsel for the petition. No one has represented. The respond number 1 to 6, no name of 2 councils are already been reflected in the cause list. Further from the order, it is 17/3/2025, which we will set the service on. Respond number 7, 9, 11, 12, 13, 14, 15, 16, and 19 are completed. From the order of Lojima Court 2/9/2024, it is seen that one submission was made before the Lojima Court. The respondent number 8, 10, 17, and 18 are not the necessary party, and hence their names may be struck off from the memo of the petition, from the cost title of the petition. Accordingly, it was submitted by Mr. Sahad that the names of so and so, 8, 10, 17, and 18 may be struck off from the cost title of the petition. It has a good note of no. Does it seem that the service is already completed? Yeah, they do one thing. No, you can rectify it. We have not received the record till now. Call for the record. The registry will do the list the matter accordingly after vacation as an edit. So we have strike out the name of this 8, 10, 17, and 18. The strike out process, registry will do the needful, void report, and strike account the names of children.
My pleasure. As per official website, service return unserved.
Return unserved.
Unserved, Lord. The respondents are mother and son. They are residing in same residence.
So regarding the address, is there any?
This address is proper. They were out of station. While process server is
Out of station. So if it is already returned, then you have to take a fresh steps. If it is already returned, to take fresh steps on the post respond. Now, how many respondents? Only 1 and 2.
two. Only two.
Part Mr. Arali Kedant, counsel for the appellant. This note dated 16/5/2025, which reveals that the service return answer, the process return answer, with a note that the addressee are out of station. Addressee out of station for input call. In view of this, the appellant is hereby directed press steps on the respondent 1 and 2 to register AP and LGR process. LCR has already been received. Huh? Yeah, we have it. Right. As per office note, the LCR has already been received, but it's that did not be tagged along with the present the bill. In view of this, the registry is hereby directed in tagging with the LCR if already received. List the matter accordingly after vacation. We are listing it after vacation to take steps. Yes, what is 24? It's a matter
Yes, my lord. Let it come for hearing, my lord. It is already admitted
already.
after the vacation, my lord.
We need the TCR. TCR already
TCR received, yes.
received.
Yes.
Mr. K. Jain. You are K. Jain.
Lordship.
K. Jain, Tilani Council for the, oh, sorry. Mr.
R. Chakraborty.
Oh, sorry, R. Chakraborty, Tilani Council for the appellant and also Mr. K. Jain. Tilani Council, appealing for the respondent. It is submitted that the district court has already been received. The appeal is already admitted. Accordingly, registry is hereby directed to registry matter for final hearing immediately after vacation.
Lordship, in item number 25, from the affidavit in opposition, I have come to know that the petitioner number 2, the respondent number 2 and respondent number 9 has expired. Respondent number 2 has expired on 12/3/2024 and respondent number 9 has expired on 26/8/2024. So I will have to substitute the legal heirs of this respondent number.
One is 4 and 6.
Lordship,
4 and 6.
no, 2 and 9. 2 and 9.
2 and 9.
Lordship, this case has been abated already. Too much time has gone by. If they have to file an abatement petition also along with this.
Acha, I don't know whether your knowledge was your knowledge was there.
Lordship,
No, he is saying that it has been already abated automatically, but we have to
we
consider
have
the
filed
knowledge
the
and all everything.
opposition long back. We have
Okay,
filed the affidavit in opposition long back. It was written in the affidavit in opposition also.
Oh,
So
long
we will
back.
have to,
When, as per you?
on last occasion, it was listed on 4/8/2025. But due to inadvertent mistake from our side, there was no representation. So I could not place the facts before your.
Otherwise, you have filed your affidavit in opposition when?
In the month of September last year.
September.
Last year.
Last year means 2020.
2024.
So obviously it was long back.
Yes, Lordship, it was long back, but because on 4/8/2025, we could not place the matter. So I may be given one chance to at least
Let them file. You can file your objection. If it is.
Will file.
Now you are suggesting that along with the substitution, one abatement has to be should be there.
Also be filed.
But Mr. S.N. Tamuli, not come to me as a 25. Part Mr. S.N. Tamuli, the learned counsel for the petition. Counsel part Mr.
S. Afridi.
S.
Afridi. My name is not reflected there.
You're appealing for someone or
D. Goswami.
D?
D. Goswami.
D. Goswami. For D. Goswami. So you are representing respondent number 1, 2 and 3 and then 8, 10, 11.
Not 2, 1,
1, 3.
except 2 and 9. I'm appealing
Acha.
for.
Appealing for 1, 3, 8, 10 and 11. Mr. Tamuli submitted in this record that he came to know about the expiry of the respondent number 2 and 9 only after perusal of the affidavit in opposition filed by the other respondents. Mr. Tamuli further submitted in 4/8/2025. The appellant remained unrepresented due to some inadvertent mistake and for which they could not go through the affidavit in opposition which was filed by the respondent. Accordingly, Mr. Tamuli submitted that they need some time to file the substitution of the legal heirs of respondent number 2 and 9. 2 and 9 post. In this context, Mr. Afridi submitted that the cases against the respondent number 2 and 9 has already been abated as they have filed their affidavit in opposition in the month of September 2024, intimating regarding the date of respondent number 2 and 9. In view of this, the petitioner is hereby asked to directed to file the interlocutory appeal both for substitution as well as for abatement for vacation of the vacation of the order of abatement. But not a petition accordingly for abatement as well as for the substitution. After vacation will be listed?
Yes.
List the matter accordingly.
The date may be fixed.
You want any date here? Date definitely it will go up to November. Otherwise, if it is after vacation, it may be somehow
Yes,
it may be
yes.
managed. Otherwise, in
Lordship,
November.
Lordship.
So after vacation,
Yes.
26.
Lordship, this revision petition has already been admitted, stay has been granted. They sought for time.
May I, Lordship, I seek 4-week time for filing
Like,
affidavit.
I will have no
filing
objection.
affidavit.
This week only I will.
No objections.
And as per you, it was already admitted,
Admitted.
admitted and stays.
State about the judgments, trial court as well as first appellate court. My prayer, further prayer is that let the matter be, stay may be extended.
You are Mr. P.S.
BK Bhagavati.
P.K. Part Mr. P.K. Bhagavati. Okay. Petitioner and also part Mr. S.C. Ross.
CS, right.
Oh, sorry, C.S. Ray, the learned counsel for the respondent. It is submitted by Mr. Ray that he needs some time to file their affidavit in petition. In view of this, prayer is allowed. Let the matter be listed immediately after vacation as a tentative fixed by the registry. Until then, the interim be continued till next day. So your interim stay will be continued till next.
May it please your lordship. So in this case, the affidavit of the respondent has not been tagged in the record. LTR has received already. So matter may come after vacation, till then their affidavit may be tagged.
My lord, we had filed an affidavit on 28/8/2024. Against that affidavit, my lord, the petitioner had filed a rejoinder application. Now, my lord, this affidavit is not in the record, my lord. My lord, a direction may be passed to the registry to tag the affidavit dated 28/8.
Affidavit is not there or the reply is not there.
Affidavit is not there. The reply is there, but the affidavit is not.
Affidavit is filed by you,
Yes, my lord, on 28/8/2024, my lord.
28/8.
Yes, my lord. 2024.
No, sir, after this matter is taken up, we will be allowed to verify the LCR also and the record also. To see.
But during court hours.
Yes, yes. We filed one rejoinder also in our case, but whether that is also tagged or not, that is not clear to us. That
The
rejoinder is-
rejoinder most probably already there. He
Yes,
has
yes,
already
yes.
received. So now the case is, why it is in order column, it can be fixed for
It may be for admission. only.
admission
Yes,
can be.
My lord, however,
Otherwise, how many respondents you have already appeared for all the?
yes, my lord, yes. However, my lord, without the affidavit, my lord, cannot be come up for admission.
They may find a
We-
phrase affidavit or
We can direct the court.
Yes, yes, sir.
G. Alam. Sure. Sharma. You are Mr. Sharma, isn't it?
yes, Lord. Lordship, my name is not in the post list, but I have
R. Sharma,
signed up
come to know.
power.
You have filed your power already?
Yes, Lordship. Our name may be some name of R. Sharma and D. Mojumdar, senior advocate.
The Mujumdar is also there.
Yes, sir.
R. Sharma, the learning for the petitioner, also card Mr. You are
GMTS, my lord.
Imtiaz.
GMTS.
GMTS, the learning counsel for the response. Next, it is submitted by Mr. Imtiaz that they have already filed their affidavit in opposition and to which the petitioner has also filed their affidavit in reply. From the record, it is seen that the affidavit in reply is available in the case record. However, the affidavit in opposition is not tagged with the case record. And accordingly, it is submitted that the registry may be directed to tag the affidavit in opposition with the case record. Further, it is submitted by Mr. Sharma that he, along with senior advocate Mr. D. Mojumdar, had already filed their accordingly to reflect the name. In view of this, the registry is hereby directed to reflect the name of Mr. R. Sharma and Mr. D. Mojumdar in the cause list on the next list. So we are listing it in admission column. And we may give a direction to the, in the meantime, if these things are available, then we can hear for the admission.
Yes, ma'am.
Registry further directed to, and this one again as per our So it will be after vacation
Yes, ma'am.
in the admission column.
Yes,
This
my
is the
lord,
matter
I
according-
pray for a date, man. A date may be fixed.
Date, in that case, date 2 will be in the month of November.
Yes, my lord.
In
Can
the
it
month
be
of
on,
November,
It's on 27 October.
October, we
Not
don't
possible.
have any. If it
Then
is
not-
there, if we insist on that, then it will come on our.
No, we shall make mention on our convenient date for listing. Then we shall make mention
Yes, then it, that
for listing after vacation. Any
immediate after vacation. Then let it be on after vacation in admission column.
Yes.
It will be listed.
Obliged. Deeply obliged.
May I please, Your Lordship?
28.
28. The matter has been admitted, my lord, on earlier occasion and PCR has been called for.
You are for the respondent.
Yes. Not the decibels here.
You're Mr. Talukdar.
Yes.
Your name is not reflected. No?
It's for
Caveat teacher. Caveat was there, na?
Pardon, my lord?
Caveat was there.
No pivot.
on the earlier occasion, he is appeared, my lord.
Huh?
For the sole respondent, he is appeared on the earlier occasion, my lord. My lord may produce the order dated 22/8/2023.
No, then you are appearing for whom?
I am for the respondent number 1, Sobita Sharma. I have got the
He is
information.
the sole respondent, no?
Sole respondent.
Iya, tapi kita kok enak. So Sobita Sharma.
Yes. It is an interesting case, my lord. It is an interesting case, my lord.
Acha.
So the matter may be hard.
That's it.
A record may be called for. And that may be it.
What can we call for?
Record entire.
Record.
Yes, sir.
Record आहे से नहीं.
Ahani bar.
You are Mr. Assemble. Had Mr. Assemble Ilane Council appellant and also had Mr. D. Talukdar Ilane Council appearing for the sole respondent. Matter is already admitted for hearing. Registry is directed to call for the case record. Issue reminder accordingly.
My lord, date may be from 14/11. 14/11.
4011.
14/11.
Want to fix it? 4011 will do.
My lord.
List accordingly. 14. So we may hear the matter, so let the record be come. So if record comes on that day, we may hear the matter. So can it be, but without record, we cannot fix it for.
Yes,
hearing.
yes.
That's why you can take a date prior to that, then only, otherwise it will be delayed again.
Pardon?
If you fix it on 14/11,
Yes, ma'am.
I don't know whether record will reach or not. After reaching of the record, only matter may be listed for hearing.
Yes. Yes.
That's why I'm saying that let it be immediately after vacation so that one date can be there. If we,
No, I will try to bring the record. I will try. I am for the respondent.
why you will try?
Yes.
Why you will try? Court will try.
Oh, yes.
There's no need of try
Yes.
by you. Huh? Okay, immediately after vacation we will.
Yes.
Or if you want any date, then 14/11 will be date.
14. Yes.
14.
Oh, okay.
Yes.
14.
Obliged.
Oh, yes.
I do feel.
Eight, please, your lordship. In this matter, my lord, On the earlier occasion, my lord, 24/3/25, my lord, the matter was admitted and the records were called for, my lord.
It was already admitted.
Yes, my lord.
Then why it is an order column again?
My lord, we have to take service upon the respondent number 7.
7
And service is already complete, my lord. Someone is representing.
for 7.
So the matter may be taken up for hearing, ma'am.
So otherwise you are appearing, Mr. Biswas,
I'm
you are
appearing,
appearing?
I have the instruction to appear for all the respondents. Though we have filed a Wakalatnama on behalf of respondent number 1 by of a caveat. So for the rest of the respondents, I'll file the Wakalatnama.
You are going to.
He is appearing for respondent, proper respondent number 7.
7. Others you are appearing.
Others. 1 to 6. 7.
You are Mr.
I'm appearing on behalf of N. Upadhyay, ma'am. S.
N.
Upadhyay.
Your good name?
S. Upadhyay, ma'am.
Heard Mr. S. Upadhyay, appearing Mr. N. Upadhyay for the effort. And also heard Mr. S. Biswas, done it council caveat was a caveat picture. One
Caveat was discharged.
already discharged.
Yes.
Appearing on behalf of respondent number. Then you are going to appear behalf of respondent number, all respondents
All the
will 1 to
respondents.
6.
Yes.
1 to 6. And Mr. S. Datta, the learned council appearing for the respondents. The service is already completed. The record we have received here.
Yes.
Receive.
The record is already received. Matter will be listed for final hearing as related to bill by the registrar. Let the matter be listed after vacation will do.
Any date, my lord.
In the
Date
month
may
of
be-
November first week.
6th of November. 6th of
Deeply village.
May I please, Your Lordship? Your Lordship may peruse office note dated 9/6/2025, Your Lordship.
Yes.
Your Lordship, notices with respect to respondent 13, 17, 24, and 28 were served. Notices to respondent numbers 18, 19, 20, and 21 were received by the wives of the said respondents. Notices to respondent number 5, 6, 7, and 15 were received by the office assistants. Respondent numbers 22 and 23 were received by the son of the said respondents. And as per the report's notices, notices with respect to respondent numbers 8, 14, 16, and 9 could not be served, Your Lordship. With respect to respondent number 9, insufficient address. Respondent 11 refused, returned to sender. Respondent 12, addressee moved. Respondent number 18 with no comment on the envelope, Your Lordship. Your Lordship, on the last occasion, as per the order dated 7/4/2025, my learned friend was directed to seek instruction with respect to respondents number 8, 9, 10, 11, and 12, as they are the relatives of respondent number 1 to 4, with respect to the addresses of the said respondents, that is 8, 9, 10, 11, and 12. My learned friend has furnished me a detailed copy of the addresses of the respondents, Your Lordship. However, Your Lordship, respondent number 5 and respondent number 4 have already expired, Your Lordship. So perhaps I need to file in 10 and 16. And 10 and 16 as well, Your Lordship. 10 and 16, Your Lordship, has expired, Your Lordship. Perhaps, Your Lordship, I need to file an interlocutory application substituting them, Your Lordship.
So as per instructions, respondent number 4, 5, 10, and 16. Right?
No, Your Lordship, 10 and 16 only, Your
10
Lordship.
and 16.
Yes, sir.
So you are Mukherjee, you are appearing for whom now?
1, 2, 3, 4.
1, 2, 3, 4,
25,
25.
29A and 29B.
So now we have provided the addresses of 8, 9, 10, 11, and 12 already.
Yes.
So
Also 13, 14 also.
Huh?
13, 14 also. They are also my relatives. Yes, sir.
13, 14.
Yes.
So as per the office note, services completed on
Yes, Your Lordship.
13, 17, 24,
And 28, Your Lordship.
28. 13, 7, 4. And 18, 19, 20 can also be,
Yes, and 21
can
also.
be considered.
Yes, Your Lordship.
18. And 5, 6, 7, and 15
Yes, Your
is
Lordship.
by office assistant.
Yes, Your Lordship. It can also be considered perhaps.
Right.
Yes, Your Lordship.
The DS Deccan.
Yes, Your Lordship.
Pardon,
May I
DS.
pray, Your Lordship? Your Lordship, with respect to respondent number 22 and 23, those services have also been.
Yes, I have already marked.
Yes, Your Lordship. Much obliged, Your Lordship.
But DS Deccan, they can
Yes.
respond to the petitioner and also for Mr. J. Mukherjee, and then consider reading the number 1, 2, 3, 4, 25, 29A, and 29B. This note dated 9/6/2025. The service may be notice B may be deemed to served on respondent numbers 13, 17, 24, 28, 18, 19, 20, 21, 5, 6, 7, 15, 22, 23, 26, and 27. But it is submitted to Mr. Decca that as per the in person to order dated 7/4/2025, the respondent has already provided the present address of the respondent number 8, 9, 10, 11, 12, 13, and 14. In view of this, Mr. Decca submitted that he will take necessary steps in issuing notice to the said respondents in their new and present address. It is further submitted by Mr. Decca that it has come to the knowledge that the respondent number 10 and 16 has already expired, and hence he will file the interlocutory application for substituting the names of the legal heirs of the respondent number 10 and 16. Let the matter be accordingly listed on immediately announced after vacation as on a date to be fixed by the registry. And in the meantime, the petitioner will also take necessary steps for filing the interlocutory application, substituting the names of the legal heirs of the respondent number 10 and 16.
Much obliged, Your Lordship.
The morning hour.
In 31, we did not get the receipt, did not receive the notice. 32 has appeared, against the same subject matter.
Yes, Mr. Samaria was there in the morning hours, so he submitted that in 31 you are appearing, na?
31, 32 I
32 also you are appearing or no? Not appearing.
Not, has already appeared. I filed my Akalat Nama, so 32.
No,
But in 31, you did not get any receipt, did not aware about this case actually.
In
I will file
30,
it.
31 you are appearing as that?
31, I'm appearing on behalf of the petitioner, my lord.
In
Same
30?
respondent, same
No, no, in
respondent.
30
31, my lord.
for the respondents.
For the petitioner, my lord. I'm for the petitioner.
So
The
then
respondent is the same.
Respondent is same, my lord. In item number 32, also the same respondent.
I understand. No, you are appearing for whom?
I'm for the petitioner, my lord.
Petitioner in which item?
Item number 31, my lord.
Item number 31.
31.
So in item number 31, you are appearing as a
Respondent number 1. But he did
respondent.
not get any receipt, notice from this court. But same 32 and 31, respondent number is the same.
So you're going to represent the
Yes, yes, yes.
respondent in both 31 and 32.
For the 31 and 32.
So 31, you are Mr.
A.N. Sharma.
A.N. Sharma. 31 report heard Mr. A.N. Sharma, the learned counsel for the petitioner. So heard MS. You are MS?
MD
Mid.
meeting.
MD mid.
MD meeting.
MD meeting. So in 31, how many respondents are there?
Sole respondent.
Sole. Appearing submitted that though they have not received the notice officially from the court, but she would represent the sole respondent. Sole respondent. Yeah, TCR has already been received. Whether it is admitted?
Not admitted.
Not admitted. TCR has already been received. Matter may be listed for action. As on a date to be filled by the registry immediately after petition. And 32 also you are appealing. You are appealing.
I am the petitioner.
You are for the petition.
It is yet to be admitted. However, stay was granted.
No, but 31 also. 31 also interim.
He is one of the respondent. I'll serve copy to him. His respondent
Anyway,
number.
in 31 also one interim is operating.
Yes,
I
yes,
think.
yes.
31 to interim are operating.
Again, same suit.
Again.
Out of common judgment.
Common judgment.
I shall serve the copy to him. What is the respondent number 3? Respondent number 1 has already appeared. Copy has been served.
So in your case, in 32, there are 3 respondents.
There are 4 respondents.
Sounds good.
Others are actually mainly respondent number 1 is the main. Others are performer respondents.
But the question is that it is the service is still awaited.
Service
However,
as regards to respondent number 1, it
She
is
already
completed.
appeared.
It is completed.
Right.
As regards to respondent number 2
Hmm.
and 3, he is here. I can serve copy to him. And
You are representing.
Yes,
Respondent number.
In item number 32, respondent number 3 is the petitioner in item number 31.
31. So I can,
I can appear on behalf of the respondent number 3 in item number 3.
as regards to 2 and 4, I will take again if necessary. We'll have to wait for the service.
Item number 32, heard Mr. P.K. Bhagavati, the learned counsel for the petition. Also heard MS. And the media, the learned counsel appearing for the respondent 1. And is submitted that the respondent number 3 is the petitioner in CRP number 30 of 2024, and accordingly it is submitted by Mr. Sharma, A.N. Sharma, the learned counsel for the petitioner in CRP number 30 of 2025, that he can represent the respondent number 3. However, the service is still awaited for the respondent number 4. Let the service be awaited till next day. This PCR has already been received. PCR has already been received. Let the matter be listed immediately after vacation as in a date to be. Okay, we are awaiting service for respondent number 2 and 4 in item number 32.
Lordship.
Otherwise, 3 and 1 I have already recorded.
Lordship. As regards to the interim pair is
Interim is still
interim is may kindly be extended.
extended. Interim granted earlier be extended till next day.
I learn this.
Yep. Yes, 33.
May it please the Lordship. Lordship, I have filed an affidavit regarding service of notice through paper publication and respondent number 3, which is the
Or
owner of the
respondent
vehicle.
number- Respondent number 3.
3, the owner of the vehicle. So Lordship, in this case, the LCR has also been received, Lordship. The matter may be fixed for hearing because it's a case where I have filed it against ex parte judgment. The insurance company was not served any notice at all. That's how it proceeded. The address was entirely a wrong address. So only thing is,
So 3 is the owner. Through
Three is the
paper
owner.
Application you have submitted. I mean, circulated, and number 1 and 2 you are appearing.
Yes, I'm for 1, 2. Claimant
1 and 2.
if three কোনো appear করেছেন না কোন Respond number 1 claimant.
You are for appearing for respond number 1 claimant. Who is 2? 2 is
Lordship, 2 is struck off driver.
already struck. Mr. Affidavit on the paper publication.
Yeah.
Petition.
একটু কেটে ওঠান আপনার অর্ডার কেন according
It was only Okamia Protidin, another paper,
Tribune,
only one paper or
2 papers also.
Acha, 2 papers, one Assam Tribune and Protidin.
Printed.
Mr. Argus, Leonard, also for the appellate. And also part Mr. K. Sharma, the Leonard Council appearing for the response. Next point, Mr. Kusami, that the notice has already been issued to the respond number 3 of the owner to paper publication in 2 daily newspaper, two daily, so through widely circulated to daily newspaper, that is Okamia Protidin and Assam. And the affidavit to that regard has already been filed furnished by the applicant. Here we have received the case record also.
Yes, Lordship, LCR has been received.
LCR has already been received.
Received, Lordship. Received because
It can be fixed for
it
hearing.
can fix for hearing, Lordship. Immediately after that, we are not furnished with the copy of the memo of appeal.
You have not furnished it.
Dia আছে I need to দেখুন আছে দিয়া আছে আপনি সাকসেস
Not submitted, not
Yeah.
furnished.
আছে
You have received 3 copies.
Yes.
TCL has already been received. Let the matter be listed for final hearing as on a date fixed by the registry immediately. Okay, we are fixing it after vacation for
Yes.
hearing.
Problem.
May I please, your Lordship? Lordship, service is complete against all the respondent except respondent number 2, Lordship. Lordship, my humble submission is that, Lordship, during the trial, even in the trial, the respondent number 2 have not contested, so an ex parte was proceeded against him, Lordship. Lordship, my
Who
humble
is
submission,
number 2? Driver?
the owner of the offending vehicle, Lordship.
Owner?
Owner of the offending vehicle, Lordship. The address is of Lordship Kohima, Nagaland. So,
So, but as per the office note dated 8/9/2025, in regards to service of respond number 3, it has been written that the service report on respond number 3 arrived with a statement at a process server that the respondent was not at home and the notice was instead received and sent by his wife. So it has already been received.
Lordship, respondent number 3, Lordship.
Yes, yes.
I'm talking about
number three.
respondent number 2, Lord.
Oh, for respond number 2.
For respondent number 2.
Oh, acha, acha.
Address is not found, Lord.
So what is the IA for?
For condonation of delay, Lord.
What was the delay?
274 days.
So 185 days, Lord.
185.
185 days.
So now for 1, yes, you are appearing.
And for 1.
1.
I am paying for this for number 4.
4.
Only 4.
United
And
Independence.
three, those served, they have not appeared. Who is three in fact?
Honor item one.
3 is the driver.
No, here.
3 is the driver
Who
of the
is
offending
the,
vehicle.
who is the owner of the offending vehicle?
It's the company MS Horizon Marketing situated at
Whatever is
Kohima.
the company,
Yes, Lord.
two is the,
2 is the owner. And 3 is the driver of the offending vehicle.
three is the driver. And who is five?
5 is the owner of the vehicle on which the victim was proceeding on.
So five is also awaiting or what?
5 have Lordship
Already
filed their
filed.
Wakalatnama, Lord.
Appeared on Wakalat. So in regards to 185, do you have some?
We'd like to file an objection.
One file objection. You also?
Lordship, the claimant is in mentally retarded person, Lord. So here we have already submitted a mental disability certificate also during trial in the evidence, and it has been proved also, Lord. So on that basis, if delay of 185 maybe.
So you have brought the reasons. No, that is okay. That's why just I asked her. She is saying that she
Lordship,
may file one
There was no such documents, Lordship. And
regarding his
judgment-
mental illness.
Yes, Lordship. And more so, Lordship, the disease my learned friend is saying that mentally not in order. That is not reflected in the judgment, nor neither any evidence is produced before the tribunal. Therefore, Lordship, there is no evidence to that extent. Here also no documentary evidence is given to prove that. Therefore, Lordship,
Disability certificate is even.
yes, that
Yep.
is, that will be hard on merit. But while condoning the delay, there is no reason, Lordship, kindly find. Kindly see that there is no reason why this delay occurred. Only the entire case is described in the delay petition, Lordship. Only one ground they have stated.
You have
that-
reasons you have not brought.
No, only the
What
reason
are the
is that
ground of delay, why it has been delayed?
they are not aware of the thing. That is one thing. And secondly, this financial. Since it is, we have not filed any appeal, Lordship. We have already satisfied the award. It's an injury and learned judge held that there was no evidence that he sustained disability to that extent, 30%.
Lordship, the
And
claimant is.
doctor has admitted in his cross-examination that this disability certificate was issued after 5 years. There's a clear finding, Lordship, can you say? There's a clear finding. The certificate is issued after 5 years of injury. That is there. So that's why the disability not taken into consideration.
Lordship, the claimant is
So
still
far
under
as-
treatment, Lord.
So far as merit is concerned. And Lordship will find there is no evidence at all. That's why I like to file objection.
Yeah, obviously, if it is supposed in anyhow, he is supposed mentally disabled also.
Yes.
In that case, most probably the advocates or someone from his family had represented. So if he was in that, so in that case also there has to be some reason why it is delayed.
Yes, Lordship. No reason to that action.
Okay. Heard you are Mr. A. Brahma.
The Brahma, Lordship.
Heard Mr. A. Brahma, the legal counsel for the applicant, and also heard MS M. Chaudhary, the counsel for the respondent number 1. And MS L. Sharma, the learned counsel appearing for the respondent number 4. And fine. Mr. D. Chetri. D. Chetri appearing for the respondent number 5. Okay. From the office note dated 8/9/2020, that the services will be complete for respondent number 3. However, the service return answer from the respondent number 2. In view of this, the petitioner is hereby directed to issue press notice on the proper arrangement for and the present response. Next paragraph, MS Chaudhary, the learned counsel appearing for the submitted that they will file the written objection against the prayer for continuity. This matter accordingly after application, enabling the respondents to file their written objection, if any, on the prayer for confirmation.
Lordship, one thing I have noticed now, my learned friend has said, though they have stated that there is a delay of 185 days, Lordship. I could not see the record, but by order dated 5/5/25, Lordship, it is stated that there is a delay of 274. In the order, it is reflected. I could not see the record whether it is 274 or 184. 274. No, we cannot say, no, we don't see. They have stated as 185. In the cost, I
Why
think.
you stated 185, it is already corrected to 274 only. In the cost letter also, there was a
Yes.
correction.
It required
Maybe
correction.
earlier 185 or I don't know, but
Yes.
here now too it is 274. There itself. In your cost title itself, it is 274.
Cost, I think 185 or 274. Lordship record is 274.
270.
But ours is 185.
That was subsequently corrected.
Correct.
Yes.
Lordship, judgment was delivered on 26.
No, that will come later on, but the question is that after correction, most probably there was some, there may be some. So accordingly, you have corrected to 274. There was a, earlier one was, and whitener was used, and then the signature of the advocate also seems there. So that means it was corrected, but you have not submitted the corrected copy to the other side.
Even I don't have notes.
Huh?
Even I don't have notes.
Yeah.
When he does not know, that means that explanation will not be there, Lordship, in this petition, because it is not corrected. Or I think.
We'll verify, Lordship. I'll verify.
To verify means it's already here only in the case record. It was whitener was used. By using the whitener, the earlier, I don't know, 185 maybe there, it was deleted, or whitener was used, and then after 274 was incorporated by, obviously there's a signature of one at the end. At the time of deliberation, it is also pointed out by MS Chaudhary that the copy which was served to them, the delay was described as 185 days, but in the order dated 5/5/2025, the delay is 89 days. Reflected as 274 days. In that context, when we peruse the case record, it reveals that by using a whitener, the earlier delay, days of delay was delay was corrected by 274. However, there was one signature is available in the cost. In this regard, Mr. Brahmo is hereby asked to make an inquiry as to whether and thereafter he is also asked to furnish a corrected copy of the cost title of the memo to the other side. The matter be listed immediately after application. You should correct it and corrected copy should be provided.
Must oblige.
Much obliged.
Privilege, Lordship.
Yes.
My lord, in a guardianship case, my lord, the petitioner,
So why it is the filing number? It is a delay condonation is there.
delay condition, my lord, 121 days, my lord.
121 days.
So 121 days.
May I please, your Lordship? Lordship, I'm appearing for the sole respondent, Lordship.
Sole respondent.
I humbly pray that, Lordship, I may be given some time to file my reply, Lordship.
You're going to
I want to file a reply, Lordship.
Heard Mr. M.A. Islam, regarding counsel to the applicant, also heard Mr. P.P. Medhin.
Dr. P.P. Medhin, Lordship.
Mr. P.P. Medhin, the learned counsel, appearing for the sole submitted by Mr. Medhin, that he needs some time to file the history.
Lordship may fix a date, my lord. Otherwise, my lord, here, the actually basically.
It's the matter according. Well, fix the date. In month of October, we don't have any date.
My lord.
Month of October, we don't have any date. It will be in the fixed in the first week of November if you insist on that.
My lord, last of October, my lord.
We don't have any date on October. Already it is fixed. Or rather, we can fix it immediately after vacation. And if registry finds it any date
Immediately after vacation, my lord. Otherwise, my lord, here the question is, my lord, actually, what happens here? 2.5 years old child, my lord. She is actually in the custody of the respondent, but the respondent is addicted, my lord, alcoholic. and might be silent.
Lordship, all these things will be decided on
So-
merits when the matter is admitted.
And
This is
here,
a
my lord,
premature
actually,
stage to.
what happened, the family court, my lord, while rejecting my applications for guardianship, my lord, but I was granted the visitation right. I was granted the visitation right by the family court,
What is the age of the child?
2.5 years, my lord, almost 2.5 years. But the atmosphere where the child is kept, my lord, it's a very bad atmosphere. And in fact, my lord, the respondent also has the change the name of the fathers also, my lord. In my absence, after keeping the child with her, my lord, in fact, my lord, she has changed the name of the father in her documents, in the birth certificate and other documents. How can she change the father's name, my lord?
Lordship, these are.
In the absence of both the parents,
Premature stage, Lordship, I
Out
humbly
of-
submit,
we are
Lordship.
fixing it in after vacation as on a date to be fixed by the registry, that will be fixed by the registry, or if you insist on that, then it will come in the month of November.
Immediately after vacation, my lord.
Immediately,
Immediately after vacation.
immediately after vacation as on a date. to be fixed by the registry. So you can file
I
your,
will file the, meanwhile, I will file my reply.
so otherwise delay was 180.
121 days, my lord. Only 121 days.
documents
Actually,
it says
whatever, my
148
lord.
also.
After the final order was passed by the family court, my lord, I was granted the visitation right. Since I was granted the visitation right, so immediately I didn't needed to file the appeal, my lord.
Okay.
So I went to the respondent house at Joy Meghalaya, my lord. Only once I was allowed to visit my child. Subsequently, my lord, where she hit my child.
Have you made any prayer before the learned trial court below? You could have made a prayer, because if it is supposed the visitation right was there, and in fact you are not getting
Lordship,
that
all
right,
things will
then
be
you can-
decided.
Yes.
Pardon?
Lordship, all these things, my learned colleague
Ah.
is saying, Lordship is alleging. Lordship, now we are here for the continuation of delay.
No, I'm not going to hear that. As per his submission, most probably, though he has that visitation right, it was not
Yes, ma'am.
allowed or
This is
okay, but
his,
that can come with
allegation of grievance, alleged grievance.
the learned court below also, learned trial court below also. Okay, then anyway, we are fixing it after vacation.
All right, man. Immediately after vacation.
Item number 11, my lord,
I'm
that
reading
is
the
also here. My lord, can it be taken up to future, my lord, because I have
All right.
problem in the second half. Item 11, my lord.
For some reason, it was for time being. I don't
Yes,
know.
Lordship, I had
You
to
were
be
not
on
there.
the on legs, Lordship. It was on legs.
Okay.
So, my
Okay,
lord,
immediately after vacation,
well,
at the request made by the council for consent, let the matter be
a
decided
date,
immediately after vacation. You want date?
Yes,
Date will be definitely in the first week of November or October. I mean,
first week.
we don't have any October date on October, so it will come on the month of November only. If you want any date, fixed date. That's
Yes,
what I'm
fixed
saying.
date will be better. Huh? Fixed date will be better. Fixed date will be.
Fixed date. 4th of November.
No,
first
problem.
week.
Problem. Sorry.
That is it.
No.
Oh, sorry.
In the petition for condonation of delay, the office note says that answer notice has been received back, returned, my lord. And the usual process, the report has not come. My lord, may I pray that, my lord, I may be permitted to take fresh steps as well as dusty service, my lord. Because as per the information of the petitioner, the respondent is staying at in that particular address. Sometimes she is not available there. So I may be allowed to take fresh steps as well as dusty service, my lord.
So DP board applicant and also applicant. Office note dated 8/9/2025 release the day service the this return answer. How many respondents are there?
Only one.
Sole respondent. Mr. Bora accordingly submitted, he may be permitted to take precedence along with for the sole prayer allowed. Petition will accordingly take state. Registered and as well as to dusty. Affidavit will be filed in that condition. Listed matter accordingly after petition, steps will be taken within 3 of the days.
Deeply obliged.
Start
Wait, please, your lordship. Lordship, this is an application for early hearing, your lordship.
Early hearing.
Yes, your lordship.
We have no objection. I am appearing for the respondent, Lonnie Das.
Say is of 2015.
Yes.
Oh, sorry, 2013.
30.
Yes.
You
Lordship,
don't
in
have
the
any
first-
objection.
Yes, I have no objection at all.
Otherwise, it is ready for hearing.
Yes, your lordship.
The case is ready. The
Yes.
trial court record is also here.
Right.
It may be fixed after 7th of November, any date,
Yes,
any date for hearing, final hearing of the appeal,
yes.
after 7th of November.
You are Mr. R.
I'm KJ Saikya.
K.
J Saikya.
K. J. Sek. Your name.
Lordship, my name might not reflect the lordship. I'm on behalf of Mr. PJ Saikya and RS Mishra.
K. J. Sek. Yeah. Mr. And Mr. No. You are Mr. P. J.
Yes, your lordship. On behalf
You are
of the-
Mr. K. J. Sek. Your name is here.
Yes, sir.
The name is already. Sorry, I was seeing other one. Huh? Oh, 38 what I say. Sorry, your name has been wrongly reflected in item number 38 in fact.
That matter also belongs to us, your lordship.
Or belongs to you.
Yes, your lordship. We are appearing in that matter also. Next. After 7th, your lordship, any day.
7th of November.
Yes, sir.
Tell me that. We did. Yes, sir. K. J. Sek. Yeah. No.
H.K. Sharma. I am H.K. Sharma for Lonnie Das, respondent, private respondent of
You are H.K. Sharma, no?
H.K. Sharma.
Because D. Sharma is also there. That's what I'm just
D. Sharma, actually, he's an arts-law advocate. He now is the member of the Learned Tribunal, Foreigners Tribunal. He has handed over the file to me. My Ukalatnama is there.
Okay. So you are Mr. H.K. Sharma.
I am H.K. Sharma.
H.K. Sharma. Very soon. This is an application. I filed under section 151 CPC praying for early date of hearing in RSA 198 of the Code. In that context, Mr. Sharma, the current counsel for the respondent, also raised no objection and submitted that case is ready for hearing. LCR has TSTCR has already been received. In view of this, the registry is hereby
A date may be fixed, Lordship,
registry matter, yes, registry matter
after 7th of November.
for hearing after 7th of November.
After 7th of November, Lordship.
11th of November.
11th.
11th. One month.
Yes. 11th of November.
November, so and so, and the parties are
11th.
no, it may be so and so. The matter may be heard accordingly with the view, with the above view, with the above observation, with an I stands disposed of. I to dispose করিব আৰু RSA to করিব hard so and so থাকিব in as per in view of order passed in IA Civil 2593 of the 2025 list the matter on 11/11/2025 14. Both the parties are hereby asked to proceed with the hearing on the next date without action. And it 38 also you are. So what is the position of I? Why I is there?
That is also for early hearing, your lordship.
For early hearing.
Yes, your lordship.
But these are not connected, na?
No,
Not connected.
separate matter.
But the prayer is same.
Very same.
But this time, if this one is fixed up in 11/11, then obviously
After
the
1
other
week
date-
of, in the next week, your lordship, after 11.
next week on because may not be possible.
Yes.
Also. 11 or 12, 13 to 20 hearing day number 13 November. 13 November. 13th of November. 1 trip.
Deeply.
Next to 1 trip. Itu I discuss koriba same.
39.
May please, your lordship.
So I is for condemnation.
Yes, first time listed.
It is listed for the first time? How many respondents are there?
Not
6, 7 respondents. Altogether, 7 respondents. So your delay is 144 days.
Notices may be issued.
Yes, we are going to issue notice. RMS, you are M cycle. M cycle, the learned counsel for the applicant. It is an application under Section 5 of the Limitation Act. Limitation Act for condoning delay of 114 days in preparing the connected appeal against the judgment and order dated 30/11/2024 filed by learned member MSCT Bongaigaon in MSC case number 144 of the 20. Issue notice to all the respondents to register area and list the matter accordingly immediately after vacation. Steps will be taken within 3 of the 4 days. You take steps.
Oblige, Lordship.
So do we make a telephonic query, my lord? In this
Yes, what
regard,
is the
my lord,
position now?
my lord, IO over telephone submitted me that my lord, they have processed the, my lord, that is the final stage, my lord, they have processed today, my lord. And because my lord, some online mode nowadays, my lord, these are my lord transferred. Those things are going on, but he didn't provide me the charge sheet number till now. Whether shall we wait for 10-15 minutes more, or my lord, that is the proposition. Otherwise, he said the CS is made. But till now, I am not getting the CS number. CS number not received.
That means the investigation is almost completed, my lord. My lord, imposing any condition, my lord. Otherwise, the petitioner is from West Bengal and the victim is from Nalbari. So my hampering or tampering does not come, my lord. So imposing any condition and considering the length of detention, my lord, I will cooperate with the trial, my lord.
And right now also, my lord, I make a request to him so that at least if it is, my lord, just it is received, just, but not, my lord, in the written format, just in the WhatsApp, he send a message regarding that number. But that written report, we are not received. Only that, just, my lord, that message just received. Or, my lord, whether we will wait for some report or my lord. As per that, my lord, his message, my lord, but that is not the entire report. Only he mentioned in the, my lord, there is WhatsApp messenger that, my lord, Nalbari PS case number 21925, CS number 2251 25 dated 22/9. My lord, he said that the final everything is completed today. They are processed. Well, maybe it is the case. But my lord, the written report I am not receiving. I have already informed him that so immediately he can send it. The report is there available. And both in the WhatsApp and also in our official email. But only message just we did.
Well, in that case, we are listing it on Thursday.
My lord.
Thursday.
Thursday, my lord.
Because he is in custody for
Yes, my lord, 80 days, my lord. Otherwise, my lord, length of detention is
can be considered.
and my lord, that is a petitioner. Otherwise, my lord, she is outstate, my lord, from the outstate, the state of Bengal.
He's from Bengal. No?
She is from West Bengal.
So in that case, there may be a problem for procuring her attendance.
Other than that, my lord, 80 days is there, and as per them also, they are in the final stage. They have all other things are completed. Right? After from the court, my lord, I make it is in the final stage, and we are hearing these things. Then I said there is send a report there written.
It is second time bail petition, my lord. So I thought maybe consider.
But there has to be some strict condition because she is from outside.
Outside. But they might not show this my lord message, my lord. They have given us that number, my CS number. And
Okay, then we're listing it on Thursday.
Thursday. Till then, my lord, that is a written report may be called.
Whatever you can count for. Thursday, keep it the date of Thursday. 25. 25. And please consider your length of detention is also there. Let us see the report.
Ma-
25. Or Mr.
But
Koso, we
tomorrow
can-
also, my lord, we can pick tomorrow if my lord. Because only, my lord, there is a report we have to call, my lord. Only that part, my lord.
Tomorrow.
Only that report. Maybe he sent it today itself, what I understand. Maybe they are also some outside or somebody.
Tomorrow.
Tomorrow, my lord.
Tomorrow it will be 20.
I go to already here, na?
State or bond. My lord, maybe given on day after tomorrow, because tomorrow there is a possibility to be holiday, my lord. The state may be declared.
I go to you won't get any.
Wednesday, my lord.
See today. All school, college, and the business establishment will be closed. Right? But official, though, I don't know. Okay, then day after tomorrow.
Day
Okay,
after.
24. Yes, starting. So you have done from Mr. Question. Yes.
In this case, he is about 2 years, 7 months, 6 days, lordship.
2 years.
7 months, 6 days, 949 days, my lord. Charge sheet.
She has
Sir,
submitted, right?
Sir, she submitted charge frame on 12/1/2024 till today.
Charge
Five-
frame? Charge
Charge frame lordship 12/1/2024. Then 5 number of witnesses examined, my lord, out of lordship. 1 second. Out of
22 numbers of people.
22 numbers of witnesses, prosecution witnesses. And in this case, we have taken the plea regarding non-compliance of this notice under section 50 and 50A. And along with the lordship long incarceration, that is also because the court is not right now available.
Court number was?
5.
5.
In this case, lordship, our division bench also passed the judgment as your lordship is aware about this after Bihan Kumar, Pankaj Bansal and Prabir Purkast. Then the division bench passed in lordship National Investigating Agency and then Thangmailen Mate on 21/8/2025. So this is one of the aspects, and another is lordship in regarding long incarceration, lordship. I'd like to refer this Manish Sisodiya case, lordship. In Manish Sisodiya case, regarding this. In Manish Sisodiya case, lordship, it is decided that regarding application of Article 21, lordship. It has been discussed, lordship, and bail in para 50, 19, 52, and then 53, lordship.
Yes, repeat the paras. 15.
50 inside 51, 19, 52, 52 inside 10, then 53. Lordship, I would like to read the 53, the other also there. So, may I read, lordship? The court further observed that over a period of time, the trial courts and the high courts have forgotten a very well settled principle of law that bail is not to be withheld as a punishment. From our experience, we can say that it appears that the trial courts and the high courts attempt to play safe in matters of grant of bail. The principle that bail is a rule and refusal is an exception is at times followed in breach on account of non-grant of bail, even in straightforward, open and shut cases. This court is flooded with
Just a second, you are reading which para?
53, my lord. Yeah, I'm right now in
Here it starts like in the present case. Is it there?
yes.
In present case, ED matter as well as CBI.
Yes.
Okay.
Lordship got it, 53 paragraph.
Yes,
number.
yes. Huh.
May I repeat again? The High Court further observed that over a period of time, the trial courts and the high courts have forgotten a well-settled principle of law that bail is not to be withheld as a punishment. From our experience, we can say that it appears that the trial courts and the high courts attempt to play safe in matters of grant of bail. The principle that bail is a rule and refusal is an exception is at times followed in breach on account of non-grant of bail. Even in straightforward open and shut cases, this court is flooded with a huge number of bail petitions, thereby adding to the huge pendency. It is a high time that the trial courts and the high court should recognize the principle that bail is rule and jail is exception. In the present case, in the ED matters as well as the CBI matters, 493 number witness have been named. The case involves thousands of pages of documents and over a lakh pages or of these digitized documents. It is thus clear that there is not even a remotest possibility of the trial being concluded in the near future. In our view, keeping the appellant behind the bars or for an unlimited period of time in the hope of speedy completion of trial would deprive his fundamental right to liberty under Article 21 of the Constitution. As observed time and again, the prolonged incarceration before being pronounced guilty of an offense should not be permitted become punishment without the trial. So earlier also thereafter this non-judicial appeal granted by the Supreme Court Lordship. Inside 51(19) also there, if the state or any prosecuting agency, including the court concerned, has no wherewithal to provide or protect the fundamental rights of the accused to have a speedy trial, as enshrined under Article 21 of the Constitution, then the state or any other prosecuting agency should not oppose the plea for bail on the ground that crime committed is serious. Article 21 of the Constitution applies irrespective of the nature of the crime. This is their lordship. Other parts also there, but I would like to refer only Article 21 because of 2.5 year completed by the accused person, and against the accused person allegation brought by the arrested accused person that is mentioned in the charge sheet, lordship. That is one person, 2 person are the main person. They are the Shah Alam Talukdar, alias Z2, and one is lordship. I have annexed the statement, confessional statement, lordship, that is Sujal Ali, sir, Sujal Ali, lordship. He has implicated this person that he was keeping watch and he was in conspiracy with them and keeping watch of the person, lordship. Only on the basis of this statement, the accused person this person was implicated. A similarly situated person is also Zitumani Talukdar. Same allegation against him also, but the Zitumani Talukdar case also granted by this honorable court, bail granted by this honorable court, lordship. So in the merit also, lordship, end of the trial, lordship, without any chain of circumstances and based on the documents and evidence collected by the prosecution, they cannot establish any allegation against the person, because in this case, though heinous crime committed by this Shah Alam Talukdar and Sujal Ali, then they have committed the main crime, lordship. They have confessed. But there is no any evidence and against this person except this statement, lordship, and firearm used in this case, that was belongs to Jitumani Talukdar Lordship. He got bail. And that arms with Bhupen Das, he is not yet arrested till today. And arms also not recovered till today, Lordship. That is one aspect also. And the section 50, other judgment, Bihan Kumar and other, your Lordship is very much aware about that. And many a times Lordship have gone through these judgments, Lordship, and but presently this presently, my lord, our division bench passed this order. He was earlier arrested in some other case. I have last date also I have mentioned this thing. Then he was shown arrested in this case, Lordship. So in this case, Lordship, our High Court already discussed this Bihan Kumar, even Darshan also discussed, Lordship. At the time of arrest, I would like to refer this. My lord, paragraph number 11 is long, Lordship, then 12 Lordship can see. Mary Lordship. The above being said, it would be permitted to note that judgment of Supreme Court in Bihan Kumar, it has been held that the constitutional mandate of informing the grounds of arrest to the person arrested in writing has been explained in case of Pankaj Bansal, so as to be meaningful to serve the intended purpose which has been reiterated in Prabir Purkasta. The said constitutional mandate has been incorporated in the statute under section 50 of CRPC, while the Supreme Court made a further observation with the requirements of communicating the grounds of arrest to be purposeful to the friends and relatives of the arrested person as required under section 50 CRPC, in addition to the requirement of section 50 surplus 1 of CRPC. It also held that the requirement was to make the mandate of Article 20 surplus 1 of the 22(1) of the Constitution meaningful and effective, failing which such arrest may be rendered illegal. The Supreme Court thus held that the purpose of communicating the grounds of arrest to the detainee and to his relative was not merely a formality to enable the detained person to know the reasons for his arrest, but to also provide the necessary opportunity to him through his relative, friends, or nominated persons to secure his release at the earliest possible opportunity for actualizing the fundamental rights to liberty and life as guaranteed under Article 21 of the Constitution. It should also be noted that Supreme Court in Bihan Kumar had held in paragraph number 21C that when an arrested accused alleges non-compliance with the requirements of Article 22(1), the burden would always be on the investigating agency officer and agency to provide compliance with the requirements of Article 22(1). In the present case, the appellant has not been able to prove that they have complied with the requirements of Article 22(1) insofar as the communication of the grounds of arrest of the accused respondent had been communicated to his family members. So in Darshan, the Supreme Court had negated the submission of the learned counsel for the accused respondent that an arrest would be illegal if the grounds of arrest were not furnished immediately, thereby violating Article 22(1) of the Constitution and Section 50 of CRPC. Now Section 47 of the BNSS. However, in the Bihan Kumar, the decision of the Supreme Court herein is to the effect that the grounds of arrest has to be in writing and has to be furnished to the relatives of the arrested accused. Thus, there appears to be dichotomy of views in the different decision of the Supreme Court. However, in keeping of view the judgment of the Constitution bench of the Supreme Court in so and so reported in so and so where it was held that if there are conflicting decision of equal bench of the Supreme Court, the earlier decision should be followed by the High Courts. We are bound to follow the earlier decision of Supreme Court, which is in the case would be Bihan Kumar. Thus, keeping in view decision of the Supreme Court Bihan Kumar, we are of the view that grounds of arrest in writing would have to be made known not only to the arrested person but also to the family member, family or relative of the accused person. Keeping in view the decision of the Supreme Court of State so and so Darshan etc. We are of the view that non-furnishing of the grounds of arrest in writing to the family or relatives of the arrested accused person immediately cannot be said to be illegal or violative Article 22(1) of the Constitution of India and Section 47 of the BI. However, the grounds of arrest have to be furnished within a reasonable time. In the present case, the accused respondent was arrested on so and so until that filing of the written objection of the appellant in bail application. So and so the brother or relative or of the accused or respondent had not been provided a copy of the grounds of arrest. This delay, approximately 18 days in our view, is beyond reasonable time, keeping in view the decision of the Supreme Court Bihan Kumar. As such, the requirements of the making the relatives of the accused or respondent aware of the grounds of arrest of the accused not having been made within a reasonable time, it can be said that the said delay could make the arrest illegal in terms of Bihan Kumar. We have perused the records that even that have been brought by the appellant. There is a signature of the photocopy of the arrest memo of the accused respondent, which the appellant say is the signature of the brother of the accused. We find that there is no date affixed to the said signature. On the other hand, all other signatures of the arrest memo which have been signed by the witnesses, the arrestee and the other officer making the arrest, all have dates. There is nothing to prove that the grounds of arrest have been received by the brother of the accused respondent on so and so. On that view of the matter, the submissions made by the learned counsel for the appellant that the brother of the appellant had been given a copy of arrest memo is not proved, and the said submission does not inspire our confidence. Furthermore, as earlier, the appellant in their written objection to the bail application filed before the learned special court had specifically a stand and the grounds of arrest of the accused respondent had been given to the father of the accused respondent. This stand has, however, been completely changed in the present appeal, which has been filed only so and so and so. So after that, Lordship, bail has been granted, Lordship. The perusal of the in paragraph number 20, perusal of the above two quoted clearly shows that it never a case appellant that grounds of arrest had been served upon the brother accused respondent at any point of time to 2/6/2025. As such, the turn around in the stand taken by the appellant in this appeal cannot be accepted by us, especially when there is no date of exist, a signature of the brother. So, peace alleged to memo in view of the case with the decision by the NIA court in granting bail to the accused person. Because NIA court granted bail, and that was challenged before the High Court by the NIA. So, all the things discussed here, Lordship. In our case also, in the in present case, I have not found what learned PP have granted because we could not go through the record. So, to whatever I found in the court below during the trial Lordship, we did not find any notice under section 50 or 51 Lordship. So, because of that reason, Lordship, that is one of the ground in this case. And he is inside the jail for about 2 years, half month and 6 days today, Lordship.
Yes. My learned senior colleague has already submitted, my lord, mainly on 2 points, my lord, law points. One is, my lord, the non-compliance of this grounds of arrest, my lord. And another one is, my lord, inordinate delay, my lord. That is, my lord, because my lord, when earlier rejected order, that is 15/5/2025, my lord, by this honorable court. At that point of time, my lord, 4 numbers of witnesses were examined. And out of 22 numbers of witnesses, now after that, my lord, that rejection order, PW5 was examined on 16/6/2025. One another witness was examined. That is on 16/6/2025. Race record, my lord, other parts, we don't have, my lord, till now. Now, my lord, I'm coming to the inordinate delay part. That is on the
My lord, I interrupt him. Only one submission is also there. These 5 witnesses at no point of time whispered the involvement of the accused person, the present petitioners.
Now, my lord, here it's a case, my lord, where, my lord, the date of arrest is, my lord, 16/2/2023, my lord. My lord, here, my lord, on 16/2/2023, my lord, when arrest was made, my lord, it is on the strength of a production warrant, because he was earlier arrested on a, my lord, different, my lord, he was in a different case, my lord, in, my lord, that is the, in, my lord, in CGM, my lord,
Sansari PS.
Sansari PS case number. And, my lord, another, my lord, petition was, my lord, the prayer was filed for this production warrant. And that was, my lord, passed by the learned CGM. And accordingly, my lord, he was brought before the learned CGM, my lord, in, my lord, Kamrup Metro. And, my lord, after hearing the learned Angus counsel on behalf of the accused, my lord, he was, my lord, thereafter, my lord, given for this sound arrest. That is, my lord, the fact, my lord. Now, my lord, here is a
No,
case.
but at the time of or passing order of shown arrest at the
My
time.
lord,
also-
I'm coming everything, man, one by one, my lord. Just I am placing the facts, man. My lord, I have flag marked all those, my lord, part, my lord. In the, my lord, that is the earlier rejection order, because, my lord, in the present one, my lord, those parts are not available. The CD part, my lord. So I have flag marked, my lord, all these things, my lord, the notice and all these things. Now, my lord, I am coming to the division bench order, my lord. This is the NIA case, my lord, what is relied by my senior colleague, my lord. That is where, my lord, may kindly peruse, my lord, para 16 and 17 of that, my lord, order, my lord, our division bench order, 16 and 17. May I read, my? In keeping in view of the decision of the Supreme Court in the state of Karnataka versus Darshan, we are of the view that non-furnishing of grounds of arrest in writing to the family relatives of an arrest of person immediately cannot be said to be illegal or violative of Article 22(1) of the Constitution of India and Section 47 of BNSS. However, the grounds of arrest has to be furnished within a reasonable time. In the present case, the accused respondent was arrested 19/5/2025 and till date the filing of written objection by the appellant in bail application so and so, the brothers relative of the accused had not been provided a copy of ground of. So, my lord, this is a case, my lord. That is the non-compliance of the ground of arrest in the part of, my lord, Section 48 is the 51 of the CRPC, my lord. What is in, my lord? That is a, my lord, that is a law, my lord, laid down, my lord, it is by, now it is a law, my lord, principle elaborately stated, my lord, by in the case of Bihan Kumar. Last part, my lord. We don't have any contradiction with that, my statutory right, my lord, the mandate, my lord, that must be followed. We have no contradiction on that. So, my lord, I am not now, my lord, this part only 17, their explanation is more given, my lord. That is to the brothers of that, my lord, and it is a case where, my lord, the case of arrest, my lord, not on the strength of a warrant, my lord. It's a direct arrest, my lord, case. My lord, and I arrested the person. We have no contradiction on that. Now, my lord, here from the para 16, my lord, how the honorable division bench of this honorable High Court make it clear that they are not saying that there is some contradiction in the matter of Darshan, my lord, or Bihan Kumar. No contradiction. It's a more explanation, make it more clear, the law and the right for everyone, my lord, protected by the Constitution of India. Now, my lord, In the case of my lord Darshan, my lord, I'm coming to the Darshan's case, my lord. I don't know, kindly give a look to Darshan's case. Flag mark, my lord, because my lord, there are many numbers are there. My lord, may kindly produce 20.1.3, my lord, param. My lord, I have flag mark, my lord. 20.1.3. Entire 20 paragraph, my lord, Bihan Kumar is, my lord, discussed. 20.1.3, the constitutional and statutory frameworks thus mandates that arrested persons must be informed of the grounds of arrest. But neither provision prescribes a specific form or insists upon written communication in every case. Judicial precedents have clarified that substantial compliance with these requirements is sufficient unless demonstrable prejudice is shown. The word is that. Now, my lord, 20.1.4. In Bihan Kumar versus State of Haryana, it was reiterated that Article 22(1) is satisfied if the accused is made aware of the arrest of grounds in substance, even if not conveyed in writing. Similarly, in Kasi Reddy Upender Reddy versus State of Andhra Pradesh, this is a case, my lord, after Bihan Kumar. Kasi Reddy Upender Reddy. My lord, the chronology come, my lord, that is the Pankaj Bansal, then Prabir Purkayastha, then Bihan Kumar regarding this, my lord, part of arrest, my lord. Then, my lord, Kasi Reddy Upender Reddy's case. Now, my lord, it is on the 14th of August, my lord, another case, my lord, and it is on the base of 302. Here, my lord, Honorable Supreme Court, my lord, discuss everything, all the parts. It's a 302, and our case is also, my lord, regarding the 302. Kasi Reddy, Upender Reddy versus State of Andhra Pradesh, it was observed that when arrest is made pursuant a warrant, reading out the warrant amounts to sufficient compliance. Both this post Pankaj Bansal decision clarified that written individualized grounds are not an inflexible requirements in all circumstances. Now, my lord, here the case in hand is a case, my lord, by the my lord's strength of an my lord production warrant, because he was earlier arrested in another matter, my lord, and thereafter soon arrest order was passed. My lord may kindly peruse that order, both the order, my lord. Here, my lord, when my lord he was produced before the CGM, my lord, he was defended by the learned counsel engaged by him. Thereafter, after hearing the same, so my lord, that is the my lord, that is, my lord, reflected in the order, my. So, my lord, that is the purpose of the notice, so that the demonstrable prejudice would not be happened. That was not made, and it is a category of case where, my lord, by dint of the warrant, the person is arrested, not as a direct arrest by police. The category is a different one. Now, my lord, 20.1.5. While Section 50 CRPC is mandatory, the consistent judicial approach has to be to adopt a prejudice-oriented test when examining alleged procedural lapses. The mere absence of written grounds doesn't ipso facto render the arrest illegal unless it results in demonstrable prejudice or denial of a fair opportunity to defend. Now, my lord, if my lord may kindly peruse that order, my lord, that is the production order, that no demonstrable, my lord, prejudice to him, my lord. He was well defended, and by dint of an warrant, my lord, he was arrested. The category is different. My lord, in this regard, my lord, regarding the grounds of arrest, non-submission of that part, my lord, that is our, because it is a case of different category, my lord. Now, my lord, I'm coming to, my lord, another, my lord, case that is, my lord, relied by my learned senior colleague, that is Manish Sisodia's case, my lord. The ED and CBI related case, it is, my lord. Coming to that, my lord, Manish Sisodia's case. My lord, may kindly peruse para 53, my lord. Of the Manish Sisodia's case, my learned senior colleague has already submitted, my lord. May I read, my lord? 53, my lord, para 53 of Manish Sisodia's case.
Yes.
The court further observed that over a period of time, the trial courts and the high courts have forgotten a very well settled principle of law that bail is not to be withheld as a punishment. From our experience, we can say that it appears that the trial courts and the high courts attempt to play safe in matters of grant of bail. The principle that bail is a rule and refusal is an exception is at times followed in breach. On account of non-grant of bail, even in straightforward, open and shut cases, this court is flooded with huge numbers of bail petitions, thereby adding to the huge pendency. It is high time to the trial courts and the high courts should recognize the principle bail is a rule, jail is an exception. My lord, bail is a rule, jail is an exception, except my lord in some cases of Nia, my lord, where my lord in Gurvinder Singh's case, these things are there's a bail is an exception, jail is a rule. Now, my lord, may kindly peruse para 54, my lord. In the present case, in the ED matters as well as the CBI matters, 493 witnesses have been named, my lord. My lord, first, it is a case, my lord, Manish Sisodia's case. My lord, there is the order was pronounced by the Honorable Supreme Court. That is on the, my lord, 9th of August. Now, my lord, this case, my lord, what the prosecution is relying, State of Karnataka versus Darshan, it is a 14th of January, and it is a case of 302, my lord. First, my lord, our submission. Secondly, my lord, here is the case where we have 22 numbers of witnesses, my lord. And here is in Manish Sisodia's case, there is a list of witnesses of 493 numbers of witnesses, my lord. The fact remains is, my lord, one is 493, the ED matter, and we have a 302 matter where 22 numbers of witnesses are there. Earlier, when rejected, my lord, 4 numbers of PWs were examined, and thereafter, my lord, after that rejection order, another PWs also, my lord, examined. So, my lord, that is the have been named. The case involves thousands of pages of documents, over 1,00,000 pages of digitalized documents. It is thus clear that there is not even the remotest possibility of the trial being concluded in near future. The possibility, my lord, from the documents, my lord, provided and the list of witness. So that is the, my lord, matter of Manish Sisodia. Now, my lord, I'm coming to the case of, my lord, Darshan's case, my lord. Regarding on the same part, my lord, there is a long list of witnesses, my lord. There is no probability, my lord. But on 14th of August, my lord, that is the pronounced by Honorable Supreme Court. My lord, they kindly peruse the, my lord, that is 20.4 paragraph, my lord. I have flag mark, my lord, there also. Yes. 20.4. Filing of search sheet or lengthy list of witness doesn't justify grant of bail. 20.4.1. It is well settled that the mere filing of a search sheet doesn't confer an indefeasible right to bail. Likewise, the mere prospect of a prolonged trial cannot by itself outweigh the gravity of the offense. Now, my lord, this is the regarding the gravity. I am not submitting, my lord. This is a case, my lord. My lord has already rejected. The incriminating materials gathered during the investigation or the likelihood of tampering with witnesses, my lord. Here is a case, my lord. He was earlier arrested by the team of a production warrant, my lord. That is his conduct. That is till today. That is the, my lord, we can make a presumption regarding this accused person. 20.4.2. In Kalyan Chandra Sarkar versus Rajesh Ranjan Supra, this court categorically held that the High Court could not have allowed the bail application on the sole ground of delay in conclusion of the trial without taking into consideration the allegation made by the prosecution in regard to the existence of prima facie case, gravity of offense, and the allegation of tampering with the witnesses by threat and inducement when on bail, non-consideration of the same, and grant of bail solely on the ground of long incarceration vitiated the order. My lord, that is the pronouncement. And my lord, regarding others part, my lord, that is it is a case of bail, my lord. This is the prima facie not. I am not submitting all this. So that is our humble submission, my lord. After the rejection, one PW is examined. Secondly, my lord, the category of the case is something different. It is not a category of case where police directly arrested, shown arrest by a tint of an, my lord, that is production warrant. he was, my lord, produced before the learned CGM, where, my lord, he was, my lord, heard, my lord, and my lord, he every given my lord, that is the opportunity, because the defense counsel was at that point of time. So that is our humble submission, my lord, in this case.
My lord, my learned friend has stated that at the time of issuing the production warrant, because I was arrested in some other cases. In that case, lordship, at the time of arrest, as per order sheet, lordship, legal aid counsel was provided. So, my lord, in this case, there is no documents he has adduced or provided this honorable court that at the time of issuing the production warrant, he was arrested. Arrest is there. Though he is trying to show that the category is completely different, but thing is that lordship, there is a arrest. After arrest, there is no documents he has produced before the court that he notice issued to them, who issued to the accused person as well as to the family members. That has been decided in our High Court's division bench case. So notice issued to the family members. Family members engage the accused person's counsel. This was the legal aid counsel. Whether any notice issued, that has been discussed in our case in division bench. The brother though obtained the signature even after that Bihan Kumar followed lords. So that is the law. And regarding the Manish Sisodiya case, lordship, in para number 49, it is stated that long incarceration running for about around 17 months. In our case, we are not asking for any other bail. If he could complete this witness within 1 month, 2 months. Lordship rejected earlier on, lordship 15 5 2025. But lordship, since 15 to 2005, several dates already passed. So lordship, after that, who has stopped them to bring the witness? Their witnesses, lordship. Every 14 days, accused persons are present from the jail. Why the prosecution not giving the special PP in this case by the state government? Even after that, lordship, the condition of the trial is like that only one person after rejection of this honorable court since 15/5/2025. Is it a matter of proud, lordship, that they have bring one witness before the court? Out of 25, only 22, only 5 witnesses examined since the date of their arrest and after framing of charge. And they are inside the jail for about 2 years, 7 months, 6 days, lordship. What allegation they will prove against the person except the documents, lordship, 164 statement that cannot be, that they cannot establish the case on the basis of the statement of the co-accused person, lordship, without any evidence, lordship. Because CDR, they have stated earlier your lordship has stated that CDR communication is there. Well, with which number, lordship? CDR, if lordship will go, I'm not going to that rejection order, but just I want to show that, lordship. See the last page of the charge sheet. That is at page number 51, 52. They have given the list of documents, lordship. See that, lordship, 50. CDR of Chuzal and Salam Talukdar, lordship. Not my CDR, my mobile number is, this number belongs to this accused person. These are the CAF and these are the CDR we have collected, and this person was along with contact with the main accused person with the conspiracy, and he was present at that particular point of time. That is not there. And so, lordship, on the basis of what this person will, they're going to convict. This is the matter, though this is a matter of trial, but because he is inside the jail for about more than 2.5 years, lordship, without any witness, who stopped them, lordship, to bring the witness? That is the motto of Article 21. It is the mandate of Article 21, lordship. And our High Court decided to that regard, money issued within 17 months. Yeah. So Lordship, on the same footings, Lordship, co-accused, he was also same putting the Zitumuni Borma Lordship. He is also one of the co-accused. He got bail from this honorable court on the same footing, Lordship. From his he was also involved in criminal conspiracy. That is the allegation made by this Sujal Ali Lordship, and accordingly after that Lordship, he received money. That is also mentioned by the this person who recorded the statement. That person got the bail from this honorable court, Lordship. And I am the local person of this locality, Lordship. These sections under which the search frame, Lordship, these sections are not attracted to me because because I have 302, I have not murdered a person. So these arms also not recovered from my position. So this is the case, Lordship. Because these are the poor person, the main person, one encountered by the police was the main person, and other person is inside the jail. So my lord, what happened in this case? These are the poor person. These family members are suffering loss, Lordship. That's the thing, Lordship. They are local person from our locality, Lordship. He is from Patasar Kusi Bazali, Lordship. So my lord, any stringent condition, I'll face the trial, Lordship.
Yes, ma'am. My lord, as because, my lord, regarding the merit of the case, my lord, detailed evaluation of the witnesses are being done. On that part, I am not coming, my lord. If, my lord, then we can also make the submission that he is the mastermind, my lord, because, my lord, trial is going on. Only, my lord, I am relying as because, my lord, that submission was made by my learned senior colleague, my lord, along with, my lord, 20.1.3, 20.1.4, and 20.1.4, my lord, 20.2 of the Darshan's case, my lord. That may be also, my lord, recorded, my lord. 20.2, may I read, my lord? Only some para, my lord. Courts are not expected to render findings on merits of the case at the bail stage, my lord. 20.2.1, it is a settled principle that at the bail stage, courts are precluded from undertaking a detailed examination. My lord, examination always there, my lord. But at the prima facie stage, examination of evidence or rendering findings that touch upon the merits of the case. Only a prima facie assessment of the materials is warranted. The court could not conduct a mini trial or record conclusions that could influence the outcome of the trial. 20.2.2, in Niranjan Singh versus Prabhakar Rajaram Kharote, this court held that detailed examination of the evidence and elaborate documentation of the merits should be avoided while passing orders on bail application. To be satisfied about a prima facie case is needed, but it is not the same an exhaustive exploration of the merits in the order itself. 20.2.3, in Kalyan Chandra Sarkar versus Rajesh Ranjan, Pappu Yadav, in the court repeated that while detailed evaluation is not required, some reasoning must support the grant of bail, especially when the offense is great. So, my lord, on that, I am not reading, my lord, whole thing, but that is our submission, my lord. My lord, the category is a different one. And my lord, regarding the inordinate delay part, in Manoj Sisodia's case, my lord, the case is my lord, there's a 419 numbers of witnesses. And here, what we are relying is a case directly related to 302, my lord. So, my lord, that is our humble submission, and that part, my lord, not at this stage, my lord. Bail may not be.
My lord may not record the statement of the witnesses and the other document. But my lord can go through that on the basis of what these persons should be kept behind the bars. Because lordship, there is no any witness except the documents. No any witness whispered that this person was involved, except the person who accused lordship, who recorded the statement under 160. Except that nothing is there, lordship. I have gone through all the 161 statement, lordship. May not reflected in the order sheet or this at the time of passing the order. But if we go by all the statement recorded by the police during investigation, lordship, there is nothing, lordship, against this person. So after
every my lord relevant order.
After after Darshan, this our division bench judgment has been passed.
My lord, we have no contradiction on that order. 48, my lord,
Sorry,
is
he has
very much, my lord, required, my lord. Is an NIA case, arrest by the police. My case is different. Strength of my category is different. And that is explained by the Honorable Supreme Court in Kasi Reddy Upendra Reddy's case and Tansal. And there is no dispute on that.
But in our case, he has not produced any document version, whether this complied or not,
My lord,
whether
that
any.
58 notice is there. Obviously, 51 I didn't get, my lord. But rest part, my lord, he was my lord, that is my lord. Engage the lawyer, everything is there. My lord, may I
Engage
page
lawyer.
the record.
Engage lawyer.
And that is my lord explained in both.
Well, engage lawyer, I have not gone through, but as per the earlier case, lordship, that is legal aid counsel. So whether notice served or family member engaged or not, lordship, that has to be looked into.
Bit lengthy order, but yeah.
My lord, oblate.
All right.
Yeah, that's gonna be-
Wait, please, Your Worship.
Oh, in
Lordship,
the morning hours, it was
yes, but
submitted.
yes, my lord.
That
It's
one
reported, my lord.
additional affidavit was filed on 99.
My lord.
So we were searching for it, that was not there, so we called for it.
My lord.
But now why it is the production?
My lord, it was mistake on our part, my lord. Actually, my lord, what happened on the 19th, miscase was, I was also filed. And in the slip, I was also mentioned, but my colleague has mistakenly did not know to, my lord, mention that. That is, my lord, yeah.
But you have put your number subsequently.
No.
Because it seems that one, the whitener was used and then one number is put here. The number is put after using the whitener.
My lord,
Here. You can see also.
that mistake I cannot say, but because she's telling
Here
that
from-
she has
here
not
from
put
it.
any.
Don't do all these things.
Madam,
If we
for that I
made
beg
a,
because
submission in the morning hours that
My
one
lord, my lord.
additional affidavit was filed.
My lord.
And we thought that yes, if an additional affidavit is filed, we can call for.
Of course, my lord.
But subsequently, one I was came up with the production
My
one.
lord.
That was not the order.
My lord, my lord.
We thought that one additional affidavit is, we are calling for that. So that number is subsequently added. So that should not be, should be.
My lord,
with
sorry.
the court record in the morning hours,
That
it can
mistake
be-
itself seems to be misleading of this honorable court, which I do not do, my lord. This is the problem.
So
And
in
for that I
that
beg
context,
apology, my
you
lord.
made this number is there,
My lord.
and then on production it has come.
My lord.
That should not be. It is not the.
My lord,
Otherwise,
for
we on
that I
belief,
beg apology.
we on a bona fide belief we generally allow.
My lord,
If
my lord.
someone is said that one eye is there, if someone says that additional, we generally call for that. It can be heard. So if it is come on production, then I'm not going to hear this today.
My lord.
So it may be listed on Thursday.
Thursday. Oblige me.
So now your eye will come along with this.
My lord.
Sister. Will come on Thursday, we'll see to it.
My lord.